for the Chartered Institute of Arbitrators, Nigeria. My name is Efosa Ewere. I'm the chairman of the Young Members Group of the Institute. This year's conference has the theme, The New Frontiers, the Position of Young Arbitrators, and our discussion has been divided into two sessions. The first is on the practice of arbitration, current reality of virtual hearings, while the second session is on investment arbitration and the role of ADR practitioners. The focus of discussion is to improve the practice of the young arbitrator and to enlighten every one of us on the various opportunities encapsulated in the virtual world and investment arbitration, while keeping abreast with the developments in the arbitration community. The panelists in both sessions will be making a recommendation on opportunities that may be available to young arbitrators who want to take an advantage of the journey to become more efficient practitioners while discharging their roles either as arbitrator, counsel, or tribunal secretary. The two sessions will have a break of about 35 to 45 minutes. At the end of the first session, we expect that everyone that has come on this platform should come back by 1 p.m. to join the second session. Ladies and gentlemen, I can assure you that both sessions promise to be engaging, interactive, and intellectually refreshing. So please, we urge you to be a part of us till the end. I will now call on the chairman of the Chartered Institute of Arbitrators, Nigerian branch, Mr. Olatunde BUSARI, SCN Chartered Arbitrator, to give his goodwill message. Thank you.
Thank you very much. Good morning or good afternoon, whichever part of the world you are joining us from. The chairperson, Young Members Group of the Chartered Institute of Arbitrators Nigeria branch, Efosa Ewere, distinguished speakers of the sessions, and I acknowledge Nsugbe QCSA, who is a very good friend of the Nigerian branch. Only 2 weeks ago, he honored us with his presence in one of the topical issues we examined on a webinar. Rosemary, who is joining it from France, also a friend of the house. Olumide Babalola, Dr. Dalia Hussein from the Cairo Regional Center for International Commercial Arbitration, Dr. Ademola Bangboshe, Jacques Ferris from South Africa, Guled Yusuf from the United Kingdom, Leon Joroge from ICSID, Miriam Hassan, WTO. Members of the YMG, distinguished ladies and gentlemen, I'm very happy and delighted to welcome you to day one of it is by this event that we flag off the annual general conference of the Institute, because we believe that our young members represent the future of the Chartered Institute of Arbitrators. Let me take this opportunity to congratulate the outgoing chairman of the YMG, Ms. Folake Sadiq. Our tenure was very inventive. It was very eventful, and it was hard that brought particularly a lot of focus and prominence to the YMG. Our tenure has been a study in service and a worthy example for all on how to act for the greater good. I commend our example to all of you. I have no doubt that the YMG new chairman, Efosa Ewere, will rise to even greater heights. I also, on behalf of the EXCO, congratulate the leadership and members of the YMG on yet another YMG conference. Needless to say, the Nigerian branch is very proud of our young members, and we know that we are blessed with very active and resourceful young members. The theme of this year's conference is the new frontier, the position of young arbitrators. And as Efosa has said, the discussions have been divided into two sessions. The first session is on the practice of arbitration, current reality on virtual hearings, while the second session is on investment arbitration and the role of ADR practitioners. The nomenclature this year of a virtual conference speaks volumes of the different and interesting times in which we are operating. 2020 has been a challenging one across the globe, and it has required that we all rethink what we do and how we do it. While COVID-19 has been the trigger for a virtual year, many of the consequences of the migration will undoubtedly stay with us. The CRCICA has been quite proactive, and even we have rolled out more activities than ever before with the introduction of the guidelines on virtual and remote hearings, complemented by the Big Blue Button. The Big Blue Button virtual education platform was introduced by the Institute to enable the remote delivery of courses. This complements the introduction of the guidance notes on remote dispute resolution proceedings. Our members are therefore assured of continued virtual courses and online institutional and administrative support for the administration of dispute resolution. As you proceed with your deliberations, which I know will broach new and interesting grounds, I encourage you to thoroughly interrogate how operating in an increasingly virtual arena impacts what we do and how we can better leverage on this new method of operation. We must all discuss how we can enhance the practice and profession of ADR to be able to provide an impetus for the greater resort to non-court dispute resolution. We must also continue to be at the cutting edge of learning and keeping up to date with societies in an ever more rapid state of flux. The Institute, conscious of remaining at the cutting edge, has introduced mentorship program and the MSME program. And with the introduction of these two programs, we particularly have our young members in mind. The mentorship program was introduced with the aim to pair mentees with available mentors who are to dedicate at least 50 hours within a designated period to guide the chosen mentee through ways they can improve themselves as arbitrators and as counsel in an arbitral proceeding. Submission of the application to be a part of this mentorship program has commenced, and it will conclude, or it will be closed by the end of this month. The flyers have been circulated to our young members who are eligible and interested in participating in the program. Young members can obtain further details on this mentorship program from the Secretariat. The second program is the Micro, Small, Medium Enterprise Scheme, which is the small scale or small claims scheme. It's aimed at expanding the use of arbitration to resolve commercial disputes so as to accommodate disputes that fall within the monetary value of 250,000 naira to 5 million naira. And particularly, just like the small claims arbitration in most of the developed countries, I have one come in mind, and we can establish such a scheme to encourage our young members and to give them an opportunity to groom themselves and to have first-hand experience in the practice of dispute resolution. I will not take much of your time. I can see from the agenda that the our discourse during this conference will explore the many changes that lie ahead of us as young members. And I look forward to learning more from you, while I hope your deliberations are fruitful and elevating. On behalf of the EXCO of the Nigerian branch, and on behalf of all our members of the Nigerian branch, I congratulate the leadership and members of the YMG, and we wish you a very, very successful outing. Thank you very much for listening to me.
Okay, hi everyone. My name is Rita Anwiri Chinda. I welcome you to the first session for today with the team Practice of Arbitration and Practice of Arbitration, Current Reality of Virtual Hearing. If you're just joining us, you can check your Ewere app to watch the live stream or go to the YouTube channel to also watch the live stream. I'll be introducing our speakers for today. Our first speaker is Mr. Ogba Nsugbe, QCSAN. He's a graduate of Hull University in the UK. He was called to the English bar in 1985 and the Nigerian bar in 1986. When he took silk in the UK in 2002, he became the first Nigerian practicing abroad to be promoted to the Queen's Counsel, the second youngest in his year and the only black silk. By then, at the age of 35, he had already been appointed a part-time judge of the Crown Court, England and Wales, the youngest in the country at that time. He is an advocate with specialty in dispute resolution, commercial litigation, regulatory and private crime. In 2010, he featured in the Power List as one of Britain's 100 most influential Black people. For 15 years, he has headed Pump Court Chambers in London, a large common law set of chambers, and the only Black head of chambers in the Temple. He is a visiting professor of the law to City University and a senior fellow of the Nigerian Leadership Initiative. Mr. Nsugbe has had numerous appointments as arbitrator and counsel with the following arbitral bodies: LCIA, ICC, and ICSID. He is cited in all professional guides to the legal profession as a leading practitioner both in the UK and Nigeria, and in 2019 he was ranked as the leading barrister by Chambers Global. To view his detailed bio, please go up to the Ewere app platform, and we'll be talking about the gamut of virtual hearing arbitrator's perspective. Our next speaker is Ms. Rose Rameau. She is the founding partner of the Rameau International Law in Washington, D.C., and a fellow of the Institute in the UK. She is a former Fulbright scholar at the University of Ghana School of Law, where she taught investment and international commercial arbitration between 2014 and 2016. She's licensed to practice law in Paris, France, Washington, D.C., Florida, New Jersey, and is also a barrister and solicitor of the Supreme Court of Ghana. She is a 2020 Abasil Mel Rasmussen Awardee for the advancement of women in international law and a board member of Arbitral Women. She's a member of several arbitral bodies and a listed arbitrator with some arbitral institutions like the Kigali International Arbitration Center, the British Virgin Islands International Arbitration Center, and others. To read more on her bio, please check the Ewere app. She will be talking about the Council's tool for virtual hearings. Our next speaker is Dr. Dalia Hussein. She is the Deputy Director of the Cairo Regional Center for International Commercial Arbitration, CRCICA, an adjunct professor at the Law Department, the American University of Cairo, and a lecturer at the Faculty of Law, Zankazi University. She worked as an administrative prosecutor in Egypt for many years and later became a practicing lawyer with specialty in international arbitration law, and has represented states and private bodies in commercial and investment disputes before the following arbitral institutions like CRCICA, ICC, ICSID, and DIAC. She has taught business and contract law at the French and British University in Egypt. To check out her detailed, beautiful profile on the Ewere app, she will be talking about gains and pitfalls of virtual hearings, the institution perspective. Our next speaker is Mr. Babalola Olumide. He is an author of Casebook on Data Protection, the first and only Nigerian law textbook on data protection, and 4 other published books to his credit, including the Babalola's Law Dictionary, repeated as the Nigerian's first law dictionary. He is the managing partner of Olumide Babalola LLP, an awardee of the Nigerian Rising Star Award, and a member of various professional bodies such as CRCIArb UK, International Bar Association, International Network of Privacy Law Practitioners. He has successfully litigated in courts of records in Nigeria and regional courts in Africa, including the ECOWAS Community Court of Justice. His area of specialty is on cybercrime, digital rights, consumers' rights, privacy, and data protection. To view his full bio, please check on our Ewere app. He'll be talking about the interplay between data protection and virtual hearing. Say a big welcome to all our speakers, and I'll be introducing our moderator, Ms. Efosa Ewere. She is the current YMG chairman. Ms. Efosa, over to you, please.
Thank you so much, Peter, for that introduction. And I also use this medium to thank all our panelists for taking out time from their busy schedule to make this event. Well, I'll start with the learned silk. I want to assume everyone has heard about virtual hearing. If you're an ADR practitioner and at today you've not heard anything about virtual hearings, then maybe we're living under the rock. So I want to start with the learned silk. In your opinion as an arbitrator, what would you say are the major advantages of virtual hearings, and how can we ensure procedural fairness in the context of virtual hearings?
So good morning, distinguished ladies and gentlemen. I send my specific congratulations to the young arbitrators for putting this on. And I certainly commend the Nigeria branch of CRCICA for its stewardship under Mr. BUSARI, SAN. So in answer to your question, Efosa, there are many advantages of virtual hearings. So we're looking at cost effectiveness. It saves significant costs, time and funds. Of course, it eradicates the need for travel. Just as we are all sitting here in all our different parts, we're able to convene together and to discuss some of the pertinent issues of arbitration, sitting in our offices or in our homes. So that is a huge advantage. It reduces environmental damage. There's an increasing awareness of the impact of carbon emissions, and it's incumbent on all of us to preserve our planet in the best way that we can. And that does include seeking to reduce our travel. And virtual hearings is an important part of that quest. Additionally, in my view, it increases diversity. And by that I mean, it allows younger arbitrators, it allows a cross-section of arbitrators, men and women, to have access to arbitral hearings because, of course, there is, I think, a reduction in the obstacles to arbitration. So increasing the playing field, leveling the playing field. And of course, there's an increase in flexibility. Virtual hearings can be very flexible. They can be arranged at short notice, and they can allow for hearings to be conducted efficiently. So there are many, many advantages to virtual hearings.
Thank you so much. I would ask Ms. Rameau, as a counsel, because in view of the topic you've been asked to discuss, what are the pitfalls and advantages? What pitfalls and advantages can you ascribe to virtual? If there's any platform you would recommend for efficiency of your case management or preparation of or presentation of your evidence?
Good morning, Efosa. Thank you very much for the invitation, and I thank the chairman, Mr. BUSARI, for recognizing me earlier. I'm actually connecting from Washington, D.C., 3 a.m. I wish I was in Paris. And before this hearing, Ms. Ewere called me to make sure that I was up. So I thank you very much for the invitation. Our learners sick just outline for us the advantages. They are not any different. What I would add is just that virtual hearing, we are not new to this in the United States. I can talk from the US perspective. My first hybrid virtual hearing was back in the 2000s. And believe it or not, it was in criminal court. And it happened in the state of Florida, where the judges realized it was much easier to have hybrid hearings with the criminal defendants sitting in the jail. So the burden was more likely on me as counsel, because I had to wake up, get out of my bed 2, 3 o'clock in the morning, just like here, leave my husband who would complain, and then we'll go to a a remote location, and the jails are usually not close by. And I had to be, the reason I said hybrid, I had to be inside the jail and the judge would be remotely wherever he's at. With that said, the only difference I would add to Oba's comment is the diversity aspect of the virtual hearing. While it's an advantage, but I would speak from a woman perspective. I've been talking to a lot of women in the business. They said, oh my God, Rose, and I can relate. They said, I feel like I'm working triple. Before, my husband used to do this, but now the kids are there, everything is there. Yeah, I can be on the virtual hearing, but it's a little bit difficult for me. So I think we can all relate to a lot of advantages, but I think more importantly for counsel, I would focus today on the pitfalls. And you asked me, I don't want to endorse any particular platform, but I would say that WebEx have been the preferred platform because it's approved by the World Bank, and clearly it has the end-to-end encryptions, and you know, WebEx never had the interruption problems that Zoom had before, and basically it has worked very well, and that's what we've used in many of the courts in the US. And sometimes you may have, for instance, right now in Florida, all the virtual hearings, the platform that's preferred is Zoom because they fixed the problem. But for international arbitration, I think I am tending to stick to WebEx. Not that I'm endorsing it, but because it has worked for us here. What are the considerations? I would basically put your consideration, try to engage the parties to agree on which platform they're going to use way in advance, because in the in aspect for the virtual hearing, you have more logistical issues. You have the time zone, for instance, right now, where I'm at, you may have people in Asia, in different part of the world. So you have to make sure people agree who's gonna get up, somebody gonna get hit to getting up early, whether it's the US attorneys or somebody in Singapore or Australia. So you just have to agree about that ahead of time. And also just logistics, clearing the video conference, the audio, and how would you resolve the technical issues? Are you going to engage an actual firm to do your video conferences? And the big part for us in the US is the presentation of the evidence. And because I would assume, maybe Oba can correct me, cross-examination we're very, very big on that here. So the very first thing that we were worried about in the US, we like to catch you in the lie. And the way we can catch you in the lie is if we are looking at your face and you preparing your cross-examination, you know which party is likely to tell you something that you perceive not to be quite the truth, and you want to cross them, and you want to make sure you get the tribunal to see the body language and all that. So for that, I think you have to really agree. Are you going to have some kind of system that's going to give you a view, 360 view, where you can see everything to avoid coaching of the witnesses and all that? Lately, what I've seen, I was indirectly involved in a hearing. The other party requests to call, or they have different offices around the world where the witness was sitting in the country. They call some of the associates to actually drive in and see you where you're at, so that they can make sure there was no one else in the room. So there was another form of hybrid, so that they make sure you didn't have anybody who was coaching you. I think throughout this presentation, I only have 3 minutes. I don't want to take any more time, but there are a lot of consideration to make sure that the hearing goes smoothly, and also communication during the hearing. You may want to talk to your co-counsel. What we've done is creating WhatsApp groups, and when the hearing is happening, if you see somebody looking down and it could be just texting co-counsel saying you forget this argument or this or that. You have to have a system because it's a new normal. We are all learning about it. So that's all I have to say for now. Thank you.
Thank you so much, Ms. Rameau. So my next question would be to Dr. Dalia Hussein. We have so many arbitral institutions, and interestingly, CRCICA is one of them. So I thought it was good if you, in a few seconds, just let us know what CRCICA represents. And I would have sort of a 3-in-1 question. So aside telling us what CRCICA represents in very few seconds, we want to know how CRCICA has fared in the wake of virtual hearings. We know virtual hearings have always existed, but we would all agree that everyone has taken it more seriously in the wake of COVID than how it has been embraced previously. So Dr. Dalia would let us know how the institution has experienced virtual hearings, if there's been a significant percentage increase compared to how it used to be, and what the experience of CRCICA has been in light of CRCICA's arbitration rules. Please kindly unmute your device.
I'm sorry. So thank you very much for the invitation. I'm very excited to be among the young members of the Nigeria branch. I'll start very quickly. I have a PowerPoint that I will share. It's a lot of slides, but I'll go very quickly. So just very quickly on CRCICA. So I cannot share my screen. Very well. So I will not use the PowerPoint. So basically, CRCICA is a regional institutional center. It is an international organization that was established in 1979 under the auspices of the Asian African Legal Consultative Organization, ALCO. And the ALCO had decided to establish regional arbitration institutions in Asia and Africa, and one of them is the Cairo Center. So according to agreements between ALCO and, and the Egyptian government, CRCICA is an international organization with all immunities to the center, to its premises, and to its employees. And so I'll just go briefly. The center to date, and from its establishment to date, it has administered around exactly 1,433 cases. So it's a huge experience. In different economic and commercial sectors. Our rules are based on the UNCITRAL rules, so they are the UNCITRAL 2010 rules adapted to institutional arbitration. And so basically you find a schedule of fees for the arbitrators, you find the institution role as a point of authority, and so on. CRCICA has won many awards. One of them is by the African Development Bank, where the bank wrote a report about many centers, including CRCICA, mentioning that it was a neutral venue and independent venue, even in cases where one of the parties is an entity of the host state, so of Egypt. So this is basically a very brief idea about the center. The cost of the center, so the cost of the administrative fees and the arbitrator fees are calculated based on the amount in dispute. So we have an online calculator that you can consult even before filing your case. You can know exactly how much it will cost you. So this is about the center. What happened during the COVID pandemic, the center had many responses. So at the beginning, our rules, of course, do not provide for virtual hearings expressly, but we have some provisions related to that the arbitral tribunal should conduct the proceedings in a way that ensures the equality between the parties, ensure efficiency, and reduce the cost and time. So we had, there was of course an increase in virtual hearings. So I had my our statistics. So in 2018, we had 3 virtual hearings. In 2019, we had 5 virtual hearings, while in 2020, we had 25 virtual hearings. So you can see the difference. In 2018 and 2019, the virtual hearings were related basically to cases that we are hosting for other institutions, so conducted under the rules of other institutions, but we were hosting them, and they were partially remote. So we had witnesses coming here, and they were cross-examined. This is basically 2020. We had exactly 25 remote hearings until today. 14 of them were partially virtual, so we have either witnesses cross-examined or a whole party from CRCICA. So we had respondent coming here, and then the arbitral tribunal and the claimant are sitting in different places. We had 11 entirely virtual hearings where all the hearing used online platforms, and we also administered them remotely. So this is like what happened during the pandemic. CRCICA was making announcement. We took it over stages. So we had at the beginning, we were partially working from the center, and then we moved to work from home, and then now we're fully operational. But during all that time, we had regular announcement to users about the use of the premises, and we encouraged them to file cases electronically, to pay electronically, and there were specific guidelines issued once a month on how to do that. And then they were encouraged to use some provisions of the rules, basically provisions allowing witnesses to be cross-examined through video conferences, and also allowing the arbitral tribunal to decide on the case without holding any hearing. So it is also a possibility under the rule. So this is, I don't want to take more time, and probably later questions, I'll give more details. Thank you.
Thank you so much, Dr. Hussein. So my next question will be to Mr. Olumide Babalola, is the digital rights expert here, or data protection expert. So Mr. Olumide, in recent times, to what extent has data protection considerations affected virtual hearings in arbitral proceedings? And this question is whether it relates to an arbitrator, whether it relates to a counsel, or any participants of an arbitral proceeding.
Thank you very much. I first of all thank the Institute for the invitation. I'm honored to speak on this panel with all other very distinguished personalities. I don't always call myself an expert because I'm still learning, so calling yourself an expert will always put you on the spot. But I understand that over time, data protection considerations have not been had as far as arbitral proceedings are concerned, because you can hardly find any of the rules or any of the laws where specific consideration or specific provisions are dedicated to data protection in arbitral proceedings. I understand the Brazilian Data Protection Act, yes, has a provision that says, that makes express allowance for processing of data in arbitral proceedings. But when we need to trace to the time when the arbitration community started giving considerations to data protection. In 2015, the website of the Permanent Court of Arbitration was hacked during a border dispute between China and Philippines, and online visitors were exposed to data theft. And I think it was at that point that the arbitration community sat up and decided to begin to give serious considerations to the issue of data protection, because almost everybody that visited the website of the Permanent Court of Arbitration had his or her data stolen and might be misused in the process. Now, in 2018, the ICCA, the New York City Bar, and the CPR Institute for Dispute Resolution, they published a draft, a cybersecurity protocol for international arbitration. And that was like the first step towards giving serious data protection considerations to arbitral proceedings. And also in 2020, the ICCA, again, together with the International Bar Association, they set up a joint task force on data protection. And those ones also issued a draft roadmap to data protection in international arbitration. And all these roadmaps, all these documents started giving guidelines, started giving advisory, started giving situation report on what participants in arbitral proceedings should begin to give attention to. And it's not just the arbitrators, the counsel, all the stakeholders. Because if you look at the data flow in a typical international arbitration proceedings, you would marvel on how wide the data flow is. For example, in a publication done on this data flow, you can imagine data flowing from the tribunal to the arbitrators, to the arbitrator secretaries, or some of them might even have hidden secretaries. If the arbitrator is like a university lecturer or an engineer or somebody who works in an institution, then data will also be shared with almost every organization or every department in that institution. And we talk about the counsel, their chambers, their registrars, the accounts, the court members itself. Then when you have a counterparty, then what about the finance, the brokers, the insurance, the hearing venue, the security, the document review platforms, the document presentation platforms, the transcribers, the translators, the co-counsel. So you can imagine how wide the data is shared. And for every point where data is shared, you have data protection issues. Also in October 2020, the London Court of International Arbitrations now amended its rules, its 2014 rules, to include data protection. So gradually, the arbitration community has woken up to data protection considerations. Because first thing we must understand that arbitral proceedings do not enjoy the kind of protection that judicial proceedings enjoy in terms of immunity and what have you. And even judicial proceedings, they are also duty bound to give data protection considerations serious thought, because they have rules that bind them. So in recent times, yes, data protection has begun to influence the rules of arbitration, influence of virtual arbitration, because I mean, the last speaker spoke about the fact that WebEx is preferable to Zoom, and these are serious data protection issues that would make one platform to be preferable to the other, especially in terms of security and in terms of confidentiality and what have you. Further in my discussion, I will touch on some issues, some serious issues, ethical issues surrounding data protection in virtual hearings. Thank you very much for the invitation once again.
Thank you, Mr. Babalola. My next question is to the learned Silk. As an arbitrator, your question is going to be a two-in-one question too. So as an arbitrator, how would the tribunal deal with pre-COVID contracts which were silent on virtual hearings? Would you say it affects the jurisdiction of the tribunal? And how would that tribunal also deal with recalcitrant parties who are adverse to virtual hearings?
So the reality is that because obviously COVID times, we're focusing on this year, many contracts that were signed before 2020 are silent on the issue of virtual hearings. And indeed, institutional rules, quite a lot of them are silent on the use of virtual hearings. But the fact that a contract is silent on the use of virtual hearings does not preclude the jurisdiction of a tribunal. The jurisdiction of the tribunal is in general terms determined by, firstly, it having been given jurisdiction by the contract. Secondly, contract stipulates the governing law. Contract sometimes stipulates the seat, otherwise it has to be determined. And it also sometimes determines the institution, which will effectively govern the proceedings. So even if the contract is silent, invariably, arbitral panels do have jurisdiction to decide how they're going to hear a case. And so I don't concern myself too much with a contract that is silent on the use of virtual hearings. The critical thing for an arbitrator, the critical thing for all of us, is to ensure procedural fairness. And essentially, procedural fairness is about equality of opportunity to present your case. So you've got to make sure that each party has a reasonable opportunity to present their case. You've also got to make sure that you have equality of arms. So that essentially means that both parties are on an equal footing in presenting their case. So the crux of this is virtual hearings are obviously, in my view, an admissible way of dealing with a hearing. The crux of it is ensuring procedural fairness. Now, if I can come to Efosa, your issue around recalcitrant parties, and of course, you have them, and they are recalcitrant for any number of reasons. A party can be recalcitrant because they have a weak case. A party can be recalcitrant because at some stage in the hearing, they determine that the arbitrator may have a certain view, or the arbitrators, quite rightly, have a view on the merits, so the party starts to become recalcitrant. And even before a hearing, a party can be recalcitrant. Now, the best way to obviously safeguard a hearing which is conducted remotely is by seeking the consent of the parties to conduct that hearing. That's the best way. But if you do not get the consent, and you don't always get the consent, you have to, A, try and tease out why the party is recalcitrant, what are the issues, what's the objection, and invariably, the objection is not one that holds water, but it has to be investigated fairly. The objection quite often is a technical issue because of the challenges of technology and the fact that some platforms are unreliable. The objection can be valid in that respect, so you have to seek to address it. And if in reality it's going to affect a party's access to the hearing, and that is something that is fatal, then of course you have to abandon a virtual hearing and try and wait till you can hear something in person. But in my experience, these things are solvable. Of course, the one thing we should bear in mind is that many courts all over the world are moving to remote hearings. So even obviously in the UK, in the US, it's been there for a long time. UK here, it's been here for a significant period of time. Over Europe, in Africa, in Nigeria, we're having remote hearings. Obviously, there was some issue around their constitutionality, but I think we've overcome that with the Supreme Court's approach. So if the courts are using them, then it's going to make it very difficult for a party to challenge a remote hearing when the courts themselves have accepted them as something that can be utilized. But what you need to ensure is that procedural fairness. So if I had a recalcitrant party, I'd seek to tease out the issues, and then I'd make a decision based upon what I determine to be the fair way to proceed. And fairness is always the critical thing. And so finally, if I just deal briefly with that issue around protecting procedural regularity, the best way to do this as a young arbitrator and indeed as an old arbitrator is by pre-hearing preparation. And so you've got to look to a protocol, and there are many available. If I can just recommend one or two, you have the African Arbitrators Association protocol. You have the SOL protocol, which is very comprehensive on virtual hearings. And indeed, the the International Center for Dispute Resolution, which is the American arm of the arbitral process, they have extremely helpful guides on the issue of virtual hearings. And indeed, the ABA have produced a guide or an order. So if arbitrators are looking for an order, they can find one under the AAA's guidelines, which actually sets out how you should issue an order in respect to virtual hearings. So that makes life, I think, a lot easier. As to the institutions, the ICC, whose rules have been recently updated, didn't specifically deal with virtual hearings, but they've issued a guide in May, which specifies that virtual hearings are possible. The LCIA have amended their rules to specifically allow for it. And indeed, if you look around the world, there are a number of amendments going on, even where the rules are silent, to allow for virtual hearings. So I think we can rest assured that the world of arbitration has quickly caught up. And I think that as long as arbitrators ensure procedural fairness, they are relatively secure in going down this route. Thank you.
Thank you, Leonard Phil. So my next question will be to Ms. Rameau. As counsel in an arbitration proceeding, what's your perception to virtual hearings? Do you see it as a future of arbitration? Because if I can recall, you mentioned in the response to your first question that virtual hearings for you dates back even to the pre-COVID times. So this question is as to the efficiency of a counsel who is preparing for a virtual hearing. How does he or she ensure a smooth arbitral process with minimal technical issues? And this is as it relates to case preparation, your management of your witnesses, management of your evidence, and even your experts, as the case may be.
I had to unmute myself. Thank you, Efosa. Let me say this, even though in the US, virtual hearing, we are not new to it. Like I said, we even had the hybrid form in terms of criminal law here. I think that in the US, we are pretty much sold that virtual hearing is never gonna replace the in-person hearing. And the reason for that, because we are so deep with our cross-examination. Even if we have virtual hearing in arbitration, I cannot anticipate it to be the same in courts. There is no way. Now, if this continues for the next 5 years, maybe. But if for sure we happens to have a vaccine where people are going to be up and about, it's not going to be. I'm more inclined to think it may be some form of hybrid. So I'll give you an example. Back in 2008, I was in New York City and I had filed a notice for unavailability, which is very familiar. You know, that's what we do in Florida if we're not going to be around. And for some reason, my secretary did not deliver the motion in time. And the other party objected to me not being unavailable. They said, she has a law office, there are other lawyers. Why does she have to be the one handling the motion? The thing is, in the US, and of course, in other parts of the world, sometimes when the client hires you, they really expect you to be the one doing, presenting yourself and not your lower level associates. So it was really hard for me. So I had to, luckily I had a good relationship with the chambers of the judge, and I called the secretary and I said, I'm in New York, there's no way. Then I did an amended motion to appear via telephone. And the judge accepted that. And that caused me not having to call my insurance company, because clients sue you a lot in the US for malpractice if you don't show up. So that there is no default judgment against them. So for me, with the experience that I have, maybe the future of virtual hearing with respect to international arbitration, because international arbitration, we are in different parts of the world, definitely not for the courts. With regards to the some of the, I think you asked me a question regarding what case preparation, best practice, I would call those. Going back to WebEx, and I took a few aspects, not to promote WebEx versus Zoom in international arbitration. If I'm doing my case preparation, and then if we agreed in advance, just like Oba mentioned, if we agree on the platform, if it's going to be WebEx, so we know that the security concern is low, as Mr. Babalola explained earlier for WebEx. It does have the end-to-end encryption, and it's been approved by the World Bank Security and Risk Department. And the thing about international arbitration, for those of us who are in the business, we could have a lot of parties. So WebEx allows you up to 1,000 participants, and you have the active speaker view, and you can share documents on 2 screens, full screen size, and You can have multiple language live events, and it's actually good for interpretation, and something that I also have in international arbitration. Some of the evidence could be coming in French, and you may need an interpreter. And WebEx is very good at that. And then you have ready breakout language room. So if your clients speak French and you want to make sure it's ready for you, so all that, these would be my reason why I would go to WebEx. And also as a way of preparation, I would, in international arbitration, at least I would have my training practice a few weeks, because some witnesses, we may all be up to date to this virtual hearing. I find that from a cultural standpoint, there are people who don't like to be speaking in front of the camera. So you have to make sure you have a practice session with the witnesses who are going to be giving live evidence, so that you make sure they are comfortable, and also make sure that they have the right system and connections, they don't have any problems. You do that a few weeks in advance, I would say, as a best practice. If there is any issue, you can call your technical person, either in the firm or outside, try to fix the issue so that there are no surprises. And the other thing I have done is to have at least 3 screens. Now you would think it's crazy. The bundle could be on one screen because you want to be able to see the evidence and you want to direct the tribunal to where you're going. And you have your other screens to different laptops, so that it makes it easier for you to introduce that evidence to the tribunal. Because in virtual hearing, you're trying to do what you would have to do in the presence of the tribunal. Usually the tribunal will get the bundle, the physical bundle. You can just look, tab, see claimant or respondent, very easy in front of the tribunal. Now you're trying to do it on the platform, and you have to direct the tribunal. So I think it's easier to have one screen just for your bundle. Nothing is touching that screen, and you have your actual screen like the one where you're live, and you may have a different screen for your communication with other counsel. This way you don't lose, like for instance, right now, we know that Dalia was trying to share her screen. It's her time to talk. She's like, sorry, I can't share my screen. So you don't want to have any problem. You want your tech person to make sure everything is synchronized. You turn here, everybody is seeing the same thing. This way it's easier for the tribunal to see your evidence and then to have a smooth hearing. So there are a lot of things I think that are like best practice. And the other thing I would say, as counsel, take initiative. Let's say I'm pushing for WebEx and you have better experience with Go Meeting, Go Zoom Meeting, or Google Hangouts, or Microsoft Team, or Skype for Business. Take initiative. If you can challenge me saying, well, I don't think we like WebEx and this is what we're going to do. And then if it makes sense for the benefit of everybody to go through the virtual hearing, then you can win on having that kind of technology. And also to go back to what Oba says, most jurisdictions are publishing, alternative system. For instance, you have the US Court of Appeal for the Federal Circuit here. They issue advisory that it would hold all oral arguments telephonically during the court's May 2020. That was just back in May, but now I'm pretty sure they have amended that to have even more because COVID has taken all over the United States. And also you have the US District Court for the Eastern District of New York. They've issued a number of administrative orders regarding virtual hearing. So I think you have to know which jurisdictions or where counsels are sitting and use those as pointers and take initiative and stand by them and push if there is anybody who don't want to use the virtual hearing. think I'll stop there unless you have anything further for me for now.
Thank you very much, Ms. Rameau. The next question will be to Dr. Dalia Hussein. In view of what other panelists have mentioned, what does your institution recognize or recommend as best practice during virtual hearings? And I say this in terms of use of electronic bundles, interpreters, just like Ms. Rameau had mentioned, use of breakout rooms and the rest of it.
Thanks again. So yes, we have some recommendations, of course, but also like they are also based on some of the experiences we've seen during the pandemic. So yes, of course, the use of electronic bundles, the use of an assistant, of a technical secretary or a technical assistance for the tribunal. I think this is becoming very important. But also we have, for example, we had some hearings where the parties and even the tribunal were postponing the hearing after the pandemic. So instead of conducting the hearing virtually or partially virtually, they elected to postpone the hearing. So I think the tribunal and the parties should be aware of the time limit of the arbitration. This is a problem under some applicable laws and some applicable institutional rules. I'll also advise them, generally arbitrators and also counsels, to use institutional arbitration rather than ad hoc arbitration, because institutions can provide a platform, they can provide security and more confidentiality. I was very interested by the case of the associate who drove until the witness home to make sure that there is no one with the witness in the room. And I've just heard similar problem where one of the experts was requested by a chair of the tribunal to have 3 cameras in his room. So I think if institutions are available, it would be probably easier to cross-examine witnesses in the institution if the institutions allow it. I would also recommend doing pre-hearing tests. So yes, you have to do your pre-hearing preparation, but also you do a test with all the platforms, with the sharing screens, with all the technicalities and all the technical issues that may arise during the hearing and cause problems. I agree also with what has been said about inviting the parties to express their views on the holding of the hearing, but I would also recommend that at the beginning of the process, especially now when we have arbitration clauses that do not provide for virtual hearings, and sometimes the institutional rules are also silent on that. So probably the tribunal at the very beginning, when it issues its first procedural order or its procedural calendar, to provide for the possibility that we might hold a virtual hearing or through conference call or cross-examine witness or experts remotely. So I think it might be provided for at the beginning of the proceedings to anticipate what will happen then and avoid conflicts between the parties related to this topic. I will also invite, especially the young arbitrators and young people, to be more flexible. I was just attending the CRCICA Alexander lecture, and it was very interesting because Professor Richard Susskind mentioned that we are automizing what we are doing, but we're not doing really new things. So technology is not transforming what we're doing. We're just automating everything we're doing. So probably we have to be more open and flexible to new techniques. I mean, yes, I was very much interested about all the problems related to cross-examination, to large bundles of documents. But could we do things differently now that we have to use technology? Could we just transform the way we are used to work, we are used to draft, and we are used to cross-examine things? So I think we have to think about different ways of doing what we are doing right now. Thank you.
Thank you, Dr. Hussein. Mr. Olumide Babalola, as practitioners, we consciously or unconsciously get ourselves involved in some certain data breaches. So I would ask, what are the most likely common breaches parties of an arbitral tribunal may commit? And what would be your recommendation on data protection for arbitrators or counsel during virtual hearings? and give us some hints, especially on how we can minimize these breaches, particularly when it comes to breakout rooms. Because for us, most times we just think that breakout room is maybe another segment or another section of the whole process.
Thank you very much. First of all, irrespective of how formidable our platforms are, they are not immune from data breaches. They are not. We've seen the case with the British Airways, we've seen cases with the Google, we've seen cases with the Marriott hotels of this world. So that's irrespective of how careful you are with your platforms, with your processes, there might still be data breaches. So, okay, so the common ones we get to see are the cyber attacks on all these platforms, or I mean the popular one, the Zoom bombing, and I understand. I'm not speaking for any particular platform. I'm not holding myself out as saying they are formidable, but we've seen reports on how easy it is to bomb Zoom. I mean, you just put in https zoom.us. Then you can guess the numbers. You can play with numbers. That's how some hackers do. They just play with numbers. Just put the numbers that represent the chat rooms or the virtual meeting rooms, and then you are able to bomb certain meeting rooms without knowing specifically that they actually exist. So, I mean, another regular breaches are confidentiality and integrity of the platforms and of the processes. So, first of all, then also the regular ones, absence of legal basis. So, before you can process somebody's data that has a legal basis, the London SAN spoke about having these contracts before arbitral proceedings. I mean, generally arbitration contracts where you insert the clauses that, okay, parties would go to arbitration in the event of dispute that they can't settle within a certain time. You state the location, you state the seat of arbitration, you state the arbitral panel that you want, you state the rules and the institution that you, but most times you don't even get to state data protection clauses, but maybe that comes in when you step into the arbitral proceedings properly. I've spoken to a couple of chartered arbitrators, and they really can't situate where that comes in. Now, so you must be able to situate the legal basis for processing some of this data. Is it because we have COIL that we don't have to divulge all forms of information, especially during the breakout sessions where parties will have to divulge more than they have divulged in the joint sessions? Then the data minimization principle is often breached. So we need to ascertain what quantum of information is necessary. We are settling contract dispute. Is it necessary for you to bring in my criminal records? Is it necessary to bring in my health records? Those are extremely sensitive data that the law ascribes more protection to. So those are regular data breaches that we have in virtual hearings. Then the solutions I would always suggest, even from some of the materials I've read, I would always suggest that parties would sit down first and determine the applicable laws, especially in international arbitration. The laws applicable to me in Nigeria, speaking from Nigeria, processing from Nigeria, is different from what is applicable to Mr. Nsugbe, who is in the UK. I mean, up until December, they are still bound by the GDPR. So the provisions of the GDPR are quite different, although similar. The NDPR is similar to the GDPR, but of course, it's not as encompassing as the GDPR is. So I am bound by the NDPR. He is bound by the GDPR. So parties must understand this. Somebody speaking from North America or first from South America would most likely be bound by the laws in his own country. Maybe somebody calling from California will be bound by the CCPA. Somebody from Brazil will be bound by the Brazilian Data Protection Act. So we must first of all understand the applicable laws, because not all laws bind all of us, because data protection laws universally are resident-based. Now, the roles of the participant, we must also understand that. Who is the processor? Who is the controller? Who is the recipient? Who is the third party? And we must understand all these roles. We must understand where all these things are coming from. So if there is a recipient I am not aware of, there has to be full disclosure that these are the recipients. Because of data protection rules and expectations, they bring in more obligations on the part of the party. And it is not just confidentiality. I know a lot of us talk about confidentiality in arbitration, in arbitral proceedings. Data protection is much more wider than confidentiality. Confidentiality is just a fragment. It's just one of the principles of data protection. Data protection has about 6-7 principles of data processing. So confidentiality is just one of it. Now, the type of data to be processed, we must also understand that. So you understand that, okay, we'll talk about my name, you talk about my office, you talk about my involvement in the transactions that led to the arbitral proceedings, but we must understand the other, not general, specific data you would also have to process. So parties must also have to discuss all these things. So if you're bringing in my criminal records, we must at the beginning understand this, why it relates to the arbitral proceedings, if it is important at all, if it's not important at all. So it is not, processing of data is not at large with arbitral proceedings and with virtual proceedings. So we must understand all those things. Then the use of service providers, parties must also agree on it. Mr. Nsugbe spoke about it, and the last speaker also spoke about it. Parties must understand what service provider we want to use. Are we sticking with Zoom? Are we using WebEx? Are we using Teams, Google Teams? And we must also understand the data protection implications of some of these service providers. Then when you begin to talk about the cloud computing, you want to talk about who will be doing the e-discovery, because once we start using virtual proceedings, then some of these physical procedures would have to give way. So if we are doing virtual proceedings, we're also thinking about all e-services. So that we do discovery, and this is thinking about their data protection practices and their roles as well, and what their obligations are, on whose instructions are they processing it, who is the controller and who is the processor. Then the translators are also important. You want to know the device with which they are translated, because all those things are processing in their own rights too. So these are all the issues that we would always have to. Concerning breakout sessions, I have said it, the rules are different from the joint session. The data protection obligations are not different. The principles are not different. The expectations and the obligations are not different. So what binds the parties in the joint session also binds the parties in the breakout session. Thank you very much, Efosa.
Thank you so much, Mr. Babalola. I can see there are some people raising their hands. I would seek your indulgence. If you have any question, just type it in the chat room. If you're live on YouTube, you can also send in your questions. So I would, because of time constraints, I would want to get some bit of, would I say tips or recommendation from the Leonard Silk to let us know if, in terms of recommendation, what tips does he have for young arbitrators, particularly when it comes to them presiding as arbitrators. So they're very careful, they don't have their awards being challenged in the virtual hearing as a result from maybe issues that may have arisen from virtual hearings.
Thank you, Efosa. And having listened to Olumide and Babalola, I don't think I'll be conducting another virtual hearing. There's so many issues to think about in terms of data protection, which, to be frank, I haven't covered all of those issues in my hearings. Indeed, I haven't even disclosed my criminal records. But to come to your question for young arbitrators, tips, I think the main tip I would give is to be organized. It's extremely important because there's so many things to think about as an arbitrator. You're looking at hearing location, you're looking at costs, you're looking at preparatory activities, you're looking at conduct during hearing, testimonials, time recording, document production, online etiquette, recording, transcription, technical safeguards, as we've heard about. So by the time documents access, you're looking at cross-examination. So if you haven't been completely scared off by what you've heard, please ensure that you're organized. Now, in terms of protecting yourself against a challenge. Well, unfortunately, I'm afraid challenges are somewhat inevitable, and they are definitely on the increase, sadly. Some meritorious, some unmeritorious. But the best way to protect yourself is usually to try to seek consent of the parties in everything you do. And if you don't get that consent, to ensure that you are very strong on procedural fairness, a reasonable opportunity to present a case, and you try and tackle any kind of inhibitors that affect that procedural equality. So I think that even though we're in this virtual hearing era, I think Rose has spoken about the fact that we should be cautious about it. And I agree with that because, of course, it's the way forward and there's no going back. We know that we're going to be seeing virtual hearings beyond COVID, if there is a time beyond COVID. But for example, signing off your award, which is very, very important, I think it's still important to do that in person. So circulating that by way of courier and making sure that the ink is the ink of the arbitrator or the different arbitrators, if there's more than one, has signed off on the award, because that is something that is easily challenged if in some way the award hasn't got the stamp that it should have. But I'm confident about the ability of our young arbitrators. There's so many talented young arbitrators that we have, eager to learn and really blazing the trail. And they are far more comfortable with technology than someone like myself. So as a young arbitrator, be ready to take on learning, make sure that you're flexible, make sure that you're accessible. Make sure that when something comes in, you deal with it promptly. Don't leave it sitting on your desk, leave it sitting on counsel's desk, so that it's not you that they're looking to for something. And ask for help. So if you're dealing with an order, if you're dealing with a tricky issue, of course you respect confidentiality, but look around for where there are experienced people that have faced the same challenges in these. And there are many, many people that can help you with tricky issues. And of course, we know that those exist inside and outside Nigeria. So I think I'd end by saying that hopefully with those tips, that it's all about the learning and the eagerness to learn and the humility to accept that you don't know everything. It's been a real pleasure to listen to all of my colleagues, knowledgeable colleagues, helpful colleagues, and that is part of the learning process and steered beautifully by you, Efosa, as the chair of the Young Arbitrators.
Thank you. I'll be asking Ms. Rameau. We really don't have much time. In just a few seconds, just let us know what your recommendations or tips will be for arbitrators as counsel. I know you've spoken a lot, but if you just have any word or two, you could add to it.
I just would endorse what Oba says. And in addition to that, I'll say really, really know your platform. Don't feel pushed because as counsel, you know, we tend to, I mean, I would push for whatever I want to use. I will give 1,000 reasons. If you are on the other side and you really feel you want to use something else, you have to equally push for that and with all the respect and see if you can get your way, if you know for sure the platform will benefit you and your client. We are all used now to virtual hearing, but we have different platforms like Mr. Babalola mentioned earlier. But if you really, if you can get a consensus on really which platform that everybody likes to use, then you are halfway through. And the other thing I would say is during the hearing, you know, you have situation where people don't seem to understand. If they keep their video on, for instance, you can minimize the bandwidth. So kind of like prepare yourself and be, okay, when you are speaking, when you're addressing the tribunal, your video will be on, and when you're not, it will be off. And the other reason is that you're sitting in your home. You may want to grab a snack or a soda and make sure that also your cell phone, usually, you know, I have an iPhone which is connected with the computer and all that. When messages are popping up, I had a situation, you can actually see the other side's messages. Make sure that everything, no breach, because the other side would love to see what you're talking about. Hey, if you put it out there, thank you very much for that information. So you have to make sure you are in sync with your team. No WhatsApp communication will be popping up in your screen so nobody sees what you're saying. And also, if you have interruption in the background, like right now, I'm in my house, my daughter is still sleeping, it's early in the morning. I don't have my headphones, but if it was during the day, 1 p.m. or something when she's running around, definitely I'll put my earphone, making sure that I minimize the noise in the background, because you don't want to explain to Oba, if he's sitting in the tribunal, he's the arbitrator, he's asking, what's this noise? Then I have to explain, oh, it's my little 3-year-old making noise, or it's this. You know, you want to make sure that you are sensitive and so that the hearing goes smoothly. I won't say much, Efosa, I've said a lot, so I'll wait for questions.
Okay, thank you. My next question will be to Dr. Hussein. I just want to get a perspective from an institution, what they would recommend to young arbitrators in terms of opportunities open to them.
Well, from the institution, I think they should. There are many opportunities now, I think, for young arbitrators. So participating in moots, joining various types of training. And I think one positive aspect of the pandemic is that a lot of trainings that used to be conducted in person and required, you know, to pay a lot of money to go there and to attend are now available online. So you can really join trainings in different parts of the world. We attended lectures for very important professors. So I encourage them a lot to work and to attend as much as trainings as they can, get the maximum experience they can. Being enlisted in any institution list, of course, is a good thing. There are some difficulties, of course, because it needs at least, for CRCICA, for example, to be on our list, you need at least to be appointed for some time or to have worked as counsel in arbitration for a number of years. So you need to have experience. So don't rush things up. I mean, just don't be in rush. Take your time, but also. Look at all the opportunities that are there. I think they are very lucky. There is a lot going on. So I think they can benefit from all what the institution offers them. The CRCICA and other institutions, they have newsletters, they have journals, so they can publish within these journals. They can participate as speakers. There are the Young Arbitrators forums everywhere now, like this one, CRCICA, we have also a Young Arbitrator forum. So I think joining these forums, speaking in these forums, this might be a good starting towards being later on appointed as arbitrator.
Thank you. While the speakers were on, there was a poll. While we wait for the results from the poll, I would quickly want to, the poll. Okay, there's this question that came on. I would use this to launch my next question to Mr. Babalola. Who has the rights to retain data collected for a virtual hearing? You have the hosting platform and you have the tribunal. So we have
thank you very much.
% saying the tribunal. So we would use this to launch your question.
I see a whole lot of people saying the tribunal. Yes, it is neither here nor there. So as we speak now, there is no way all our data will be off Zoom. There is really no way. I mean, Zoom has its own privacy policy. And the privacy policy tells the whole world how it processes data. Coincidentally, we are in court with Zoom because their privacy policy says they are merely a data processor, meaning that they are processing data for everybody using their platform. But they still retain part of this data. So for virtual hearings, yes, the tribunal retains data, but Zoom also retains data. You can't take it off entirely from Zoom. They have their clouds where they store some of these things, because sometimes when you save, you can still retrieve from Zoom, depending on how you even save. Sometimes you save on your system, sometimes you save on Zoom's platform. If you save on Zoom's platform, they are retaining it. And they have their policy as to how long they can retain and why they're retaining and all the legal basis. So the issue of retention is neither here nor there. It's just like me asking you who retains data when you go to the regular courts. The courts retain, the counsel retain, the parties retain, but it now depends on the quantum or the nature of data retained by each person. Then it also depends on the transaction you have with Zoom, with the plan you have with Zoom. I understand that on Zoom, I'm using Zoom an example because I'm not so familiar with, I know WebEx, I know, but I'm not so familiar with their operations, because I'm in a matter against Zoom, I can tell you what their privacy policy states. So if you record on Zoom, you can either tell Zoom you want to record on your system or you want to record on Zoom's cloud. If you record on Zoom's cloud, of course, they retain it. But what we should talk about more is, okay, who has rights to those data? Not necessarily you retain it, because if you get it, if you're able to collect it, you can retain it on your system too. But if you are a tribunal is using the electronic platforms or the digital platforms, of course, the tribunal also needs to retain this data. So it is more useful to the tribunals than to Zoom, but only for reference purposes and for their own development of their platforms as well. But by and large, the tribunal retains the. And another thing is, even courts are not immune from data protection obligations. So how much more the tribunals? Every tribunal now must begin to have data retention policies. For how long are you retaining this data? For what purpose are you retaining it? For if you are going to delete it, what is your policy? Because people can start suing arbitrators if you retain data for longer than it is necessary, because that's part of the data protection principles. You can't retain it for longer than it is necessary. So what does the rule say about retention of all this data? What does the rule say? What do the parties agree as to retention and deletion? Is there even any agreement at all? We keep talking about consent. Consent to arbitrate is different from consent to process, because in data protection, consent is specific. I give you consent to process my data. For what particular purpose? You have to be specific. So, and in what documents do you even record this consent? I've asked for people to tell me, is there any point in the arbitral proceedings where parties sit down and agree that, okay, well, this is the kind of data that we processed. This is the purpose for which it should be processed. If there is no consent, then the question the arbitration community needs to answer is, on what legal basis are we processing our data? Is it by consent? If it is consent, it has to be in written form. In writing. Now, if it's in writing, for what purpose? To what extent? If it's not consent, is it contract? Is it for the performance of a contract? The contract has been breached already, and we are fighting over breached contract. So it really can't be for the performance of a contract. Is it for public interest? We must be able to see it. Arbitral proceedings are private. The public does not even need to know. So you can't say you are doing it for the public interest. Vital interest. Which of the parties is at the point of life and death that you now have to necessarily process data? Legitimate interest, yes, in European law, you might be able to tie it to legitimate interest, but these are conversations that must be had in the arbitration community to have some form of understanding. I understand they have a roadmap. Even the roadmap is not, can be authoritative because it can't cut across everybody's situation. So there has to be this conversation as to the legal basis, and that is important for young arbitrators too. We can begin to think on the legal basis for processing, because when we are fighting, when we are disputing over issues, people sometimes they throw caution to the wind. They process all sorts. They divulge all sorts. But while fighting over breach of contract, we might, in the process, incur some other data protection liabilities that might even be greater than what we are fighting for, actually. So these are issues that we really need to begin to interrogate within the arbitration community. Thank you very much for inviting me once again.
Thank you so much. I don't know, we have very little time left. There are so many questions on the chat room. I would just want to, in a nutshell, summarize everything. In just one word, I would just summarize what all the speakers have hinged on. The learned seal hinged on fairness in arbitral proceedings as an arbitrator. Ms. Rameau hinged on effective communication. Dr. Hussein hinged on flexibility of the use of technology and then the use of the process as an institution. And Mr. Olumide Babalola has just explained to us that consent in arbitration is not the same thing as consent in data protection. So I would go to the chat room quickly and take one or two questions. I don't think we have so much time, but I'll direct this question to the learned silk. In the light of current realities, what do you foresee as the future trend in international arbitration, or perhaps arbitration generally, a hybrid of in-person and virtual hearing, or a shift from in-person hearing to virtual hearing? And I asked the learned silk this question because I know he's a Nigerian. We have our own peculiar issues from technology and the rest. As a Nigerian, you may be aware of these things. And for someone that lives outside the shores of Nigeria, so I really want this question to be directed from your knowledge from practicing in two jurisdictions.
Thank you, Efosa. In my view, the future of arbitration, obviously, virtual hearings and technology have a huge part to play, but particularly, I think, in Nigeria, where we still have, as we know, significant infrastructure issues and problems, the use of virtual hearings and technology will not, I think, progress as quickly as elsewhere. And we need to also remember that there is something intangible about personal contact in cases. It's difficult to describe, but it's very difficult to read a witness or to read a court when you're doing it over a screen. Much easier when you are facing that person in a live setting where you can effectively face somebody eyeball to eyeball. So in Nigeria, where you may be in the middle of a hearing, maybe in the middle of a significant cross-examination, and suddenly there's an issue with light, or there's an issue with connectivity, or there's overuse, overloaded, and the whole thing just collapses. Those, I think, render the use of virtual hearings. I think it's something that is not going to take off as quickly as it does elsewhere. And I completely understand and accept the reasons for that. Definitely, it can be used in a hybrid form for hearings that are maybe not the live contested hearings. So there's the preparatory hearings, the interlocutory hearings. Virtual hearings, I think, definitely have a role to play, saves the court time. But, you know, things like the critical thing about virtual hearings is the preloading of exhibits, preloading of documentation before the hearing so that they're easily accessible when you're conducting the hearing. And we have, I think, obviously challenges in Nigeria over that. So going between the two jurisdictions, as I'm fortunate to do, those are what I see as the hindrances when I get back home. When I come out again, there's less of that hindrance, and it's something that I think will be with us for some time.
Thank you so much. You will all agree with me that it was a very engaging session and an interesting one, and I can bet that every one of us has whether even as panelists and as the audience, we may have learned one or two things. I really want to thank our speakers again for honoring our invitation and bringing out all their wealth of experience to bear. The questions can continue on the platform, the Ewere platform, and we would actually plead with the speakers that when we have those questions directed to them, they give us their response. So I would say this is the end of the first session. The second session starts by 1 p.m. We would plead that we have the same audience back by 1 p.m. and logging in to actually be a part of the second session, which is going to be investment arbitration, the role of ADR practitioners. Thank you very much, and thank everyone.